one of the things you've heard today that's really critical is this idea that this first inventor to file system is going to apply to patents or applications that contain or contained at any time a claim to an invention with an effective filing date on or after March 16, 2013. So that's that critical date we've been talking about for transition to the first inventor to file. But showing you a couple of examples, we're going to be transitioning for quite a while. If you had, let's say you had a first application filed before the March 16, 2013 date, your priority date is clearly before, you're going to still be under the old first to invent system. And that's going to be for the life of that patent, for years. And there are going to be thousands of patents that are still under the old system for many years. Taking this other easy example down here, if your earliest priority dates are after March 16, 2013, clearly you're going to be in the new system. You're going to be in first inventor to file. But what if you straddle the date? What if you're in here? What if you had an earliest filing before March 16, 2013, and then within a year, maybe you added some new subject matter and you filed a PCT application, and you're sort of straddling this effective date? Well, then there are different scenarios that could occur. You could be, let's say you had no claims that are entitled to this earliest priority date. You'd be in first inventor to file for that patent. What if all the claims are entitled to this early pre-effective date filing date? Then first to invent system. That's the patent you'll get for that situation. But what if at least one claim, it was mentioned earlier, all you need is one claim not entitled to this earliest date. Now you're under first inventor to file. So I think it's important to understand, and there may be hundreds or thousands of patents that fall in this area where you're bridging the date. So we're going to have, for a number of years, we're going to have patents under the old law, and we're going to have patents under the new law. And we're going to have patent holders maybe owning both. And we'll probably have lawsuits asserting both. So you can imagine a lawsuit where the patent holder asserts 5 patents, 3 of which are under first to invent, and 2 of which are under the new system. Can you imagine a jury trial with that? Trying to write jury instructions for both systems. A judge is trying to deal with that. So it's going to be very challenging. And the other thing is, keep in mind, this issue of whether you're entitled to priority to the earlier date, that could be a disputed issue in the litigation, right? It's not always that easy to know whether you have Section 112 support in an earlier application. So that could be disputed. So the jury may have to decide, first of all, are you entitled to the earliest priority date? And then from there, apply a certain set of law if you are, different law if you're not. So it's going to be difficult. It could be very challenging in the litigation area for a number of years when we do have patents that are under both systems. So I just wanted to make that initial point. There could be a real important effect on inequitable conduct. You already heard about this supplemental examination provision. It could be very important. This allows a patent owner to go to the patent office and present some information the patent holder thinks would be relevant to the patent, and ask the PTO to consider it, reconsider it, or correct information. Best example, prior art that was, for whatever reason, not submitted or not considered in the original prosecution before the patent issued. The patent office is going to determine, does that raise a substantial new question of patentability? And if that patent gets through this process, the patent will not be able to be attacked on inequitable conduct grounds based on that information that was considered in the supplemental examination. So this could have a real impact in patent litigation if parties actually use this procedure, mainly to strengthen a patent before litigation. So if you're contemplating litigation, you have some information that you know was not considered during prosecution, strategically you'll have to consider whether to go in for a supplemental examination to try to have that information considered before you file your lawsuit, and basically taking away a potential defense that the defendant might raise of unenforceability. So this is going to be effective September 16, 2012, and it's going to apply to all patents across the board. There are some limitations I wanted to highlight here. Now, if you already have inequitable conduct alleged with particularity in a pending litigation, you can't then go to the Patent Office and file supplemental examination. It's too late. So if it's already been alleged, it's already being litigated, this won't help you. Also, if you have a paragraph 4 notice in the ANDA drug area that's already specifically laid out a charge of inequitable conduct, you won't be able to use supplemental examination to cure that. So that's a limitation on it. If you're talking about the ITC 337 actions, supplemental examination and any related reexamination have to be conducted before the ITC action is commenced. So that's a bit of a limitation for ITC cases. And this is a third one. It's not actually in the legislation, but just something I wanted to mention. You can imagine if you're a defendant in a case and you're sued for patent infringement on a patent that went through supplemental examination, that supplemental examination is going to be under a microscope. There are going to be depositions. They're going to be attacking that submission. So if there's any argument that the supplemental examination request itself was incomplete, was misleading, was false in some way, it wouldn't surprise me if you were charged with inequitable conduct for doing that. And so I think it could be a very useful procedure, but you would have to be extremely careful if you use it, because if you use it, it's going to draw a lot of attention, and if the submission itself is somehow incomplete or misleading in some way, there could be consequences in terms of someone arguing that itself was inequitable conduct to go in. So it's not in the legislation, but it's something you'd have to be aware of. You've heard about some of the advantages. Let's talk about the issue of, is this going to, this new legislation going to mean that the end of patent litigation? Is it all validity, all going to be litigated at the Patent Office? Well, these procedures, PGR and IPR, definitely have advantages. You've heard about the lower burden of proof. It's preponderance of the evidence. That's a lot lower than in district court, which is clear and convincing evidence of invalidity. So it's lower standard. It's going to be less expensive. It's going to be faster. Okay, so those are some of your advantages. There are others. But there also are some risks, and I think you heard a little bit about them. So from my point of view, from a patent litigator's point of view, I would be very concerned about the estoppel, first of all, okay? If you go through this procedure and you lose, granted you get to go to the Federal Circuit and have your day in court, but if at the end of the day you've lost on that issue, that's it. That's it for district court, that's it for the PTO, that's it for ITC, so that issue will be gone. So you'd have to be really sure that you really want to be in the Patent Office, because if you do lose, it's final. This one concerns me. It may be true that most of the time the PTO will grant the PGR or IPR request. However, if the Patent Office denies it and refuses to initiate it, the legislation provides that's not appealable. No appeal from that decision. And in my view, there could be a practical effect in litigation that could be difficult to overcome. And what I mean by that is the Patent Office, to initiate this, they have to find, essentially there's a reasonable likelihood of success of proving at least one claim unpatentable under our lower standard, preponderance of the evidence. Now, if they refuse to institute, I could see a defendant, or a patent holder rather, later arguing that in district court, moving for summary judgment of no invalidity. And Your Honor, this argument was already rejected by the Patent Office. The Patent Office already found that it couldn't meet even a preponderance of the evidence standard. So how can they now prove this same argument in district court by a higher burden of proof, clear and convincing? So I would be very concerned about going in with my best arguments, and there is going to be some risk that if they don't institute it, you're really going to be in trouble if you're then in district court and have to deal with the summary judgment, for example. And let's keep in mind, you still have ex parte reexamination, right? That is not, as far as I understand, not affected by the new legislation. And for ex parte reexamination, there's no estoppel, right? So if you were concerned...
You can bring in 112 for this thing to do ex parte reexamination.
Ex parte reexamination is still in effect, but it's limited to printed publications prior. But
not if you do it through supplemental examination.
Through supplemental examination?
Yeah.
I'm not sure what you're saying.
You make a petition to have information considered. doesn't have to be print publication.
Okay. But there's no estoppel in regular ex parte reexam, right? So you're going to have some choices out there. You're just going to have to carefully consider the choices. The other somewhat of a disadvantage in my mind for these procedures is the having to disclose the real party in interest. Now, sometimes you may not care, it may not matter. Other times, let's say you're practicing a process in your factory and doing it in a way that maybe you may or may not infringe. There's some issue that you're infringing someone else's patent. And that patent holder may not know about that. But maybe your company wants to go try to knock out that patent. Well, if you file one of these, you're going to have to disclose that it's you. That's you that's trying to invalidate that. And is that going to make you a target for that patent holder that maybe had no idea that you were practicing a process that had something to do with their patent? So again, just something that you have to keep in mind, you have to balance. So there are some risks, and maybe these are some things that can be dealt with in implementation as well. But I do have some, from a litigation standpoint, some concerns about these procedures and whether they would be the best way in many circumstances. You've already heard about this prior use defense. I'm just going to briefly touch on it. It's a broader defense now, so it potentially could cover a broader range of subject matter. And the only thing I wanted to add is that this could have some impact on trade secret protection, because, as you know, one of the risks traditionally in relying on trade secrets is that somebody else would come in later and patent the same technology and then go to court and enjoin you from practicing that. Well, strengthening commercial use, prior commercial use, may have some effect in strengthening trade secret protection. We'll have to see, but it's a possibility to keep your eye on. So if trade secrets are important to you, you should definitely be aware of this provision and see whether it would apply, whether you meet the requirements for this prior commercial use as a defense to non-infringement. Best mode, I think we've already heard about best mode, but essentially, I think Janet mentioned that still a requirement at the patent office, but it's no longer a basis to find a patent, to hold a patent invalid or unenforceable. So that's the law now. It affects any proceedings that are commenced on or after September 16, 2011. So it's in effect for cases that are filed now. Is there a question? Yes, sir.
But the best mode still applies to any application or invention prior to September 16th?
Yeah, for lawsuits that were filed before this, oops, proceedings. The statute talks about proceedings, so exactly what that means. I assume that would include a lawsuit, for example, filed before this date, or interference. Then proceedings, then if they are filed before that date, you still have best mode as a grounds for invalidity. Yeah, so there's a definite date there where it kicks in. Does that make sense? Just wanted to briefly touch on discovery. This is always an important subject in litigation. Again, I wish I could say discovery is going to go away or discovery is going to be so much simpler in district court litigation. It's not really true. You heard about the broadened definition of prior art. Well, what's that going to mean in litigation? Well, you're probably going to have more discovery abroad. For example, if you could have prior public uses or sales or maybe offers for sale anywhere in the world become prior art once this law is effective, you're probably going to have discovery. You may have discovery in China. You may have discovery in Europe. And if it's really important to a case, there's been a prior use anywhere in the world, you're going to want to find that if you're the defendant, and you're going to have to take discovery. And that could add to some of the cost and some of the burden of litigation, frankly. I think you heard of, yes, sir.
I'm just an inventor, a lawyer, but I've been looking at this anywhere in the world discovery. How on earth do you do that?
Well, there are certain procedures you might have to go through the Hague Convention, for example, and there are,
Thinking of China,
right.
there's infringement in China is endemic. You want to get discovery in China, they're just going to tell you to take a hike.
Right. Well, it may be that the party who is in the litigation, let's say you were litigating against a Chinese company. Now, the district court, they're in the court, and so the judge has control over that party. You could order, the judge could order the party to bring the documents from China, for example. Or, it may be difficult. well, then they lose in the U.S. District Court. So for cases where the parties are before the judge, there's a certain amount of power the judge has over those parties. But you're right, in terms of third-party discovery, for example, it could be very difficult or impossible. But you're going to have to be creative about it and try to get it. You know, if you think it's there, you're going to have to find a way to get it if you're a defendant. So you also heard about some of the exceptions to prior art. We heard about that. The idea that if the prior art work related to the inventor's own work, there may be exceptions, and the statute is pretty complicated there. So there may be discovery related to the exceptions to prior art, and you've heard about that, and there's going to be some disputes about whether work really was tied to the inventor's work. Prior commercial use defense, if that is asserted, there are lots of issues that would come up in discovery there. You know, when did you start using a process? Have you used it continuously? What sites have you used it on? There's a good faith requirement, so you probably have discovery into that. Did you transfer the rights? And so on and so forth. So there'll be a lot of discovery in that if that comes up. There won't be any more discovery into date of invention, I don't think. That's no longer relevant. So that's one benefit of the new system. It's going to eliminate all that type of discovery. I still think the inventors are going to be deposed. There's been some speculation or the inventors won't have to be deposed anymore. I really doubt that. I think the inventors are going to be deposed in every single case, just like they are now. Okay, moving on, patent marking. So this is an interesting provision. Section 287 has been amended to allow patent holders to mark their patented articles with an internet address. And this is important for damages purposes. And so the internet address, basically you can update your patent numbers on your website. So as patents expire, you can take them off. As you get new patents, you can add them on the list. So just as a very practical way to mark, keep up and comply with the marking requirement, you can do it by putting an internet address. So that's an important new provision. Gives you an alternative to physical marking, which, you know, so you don't have to retool your machinery and so on, which can be extremely expensive. This applies to all cases pending or commenced on or after September 16, 2011. So again, it's in effect now. The other marking-related topic we just wanted to touch on is false marking. So you've probably heard about this, the false marking suits that have been filed in the US. Well, it derives from the statute that allows any person to sue for a penalty of $500 for each offense, each marking offense. And penalty, the recovery has to be split with the United States. So the lure of that $500 per offense recovery, and coupled with some case law, really made it very appealing for these suits to be filed. And since the beginning of the year, there were about 1,450, actually more than that, false marking suits that were filed in the United States in the last year. So the patent reform legislation is going to largely do away with that, except for a couple of situations. So the false marking suits are going to be eliminated except where they're brought by the United States, and the United States can still seek the penalty, or if a party has suffered competitive injury, they can bring false marking and seek damages. Yes, sir.
I believe it is the case, in your agreement, the United States has never, ever filed a claim.
I believe that's correct. So if essentially that's, yeah, it's on paper. That's right. I do think we are going to see some of these, and I'm talking to some damages people I know, damages experts, that we are going to see competitive injury claims. So that is going to occur. So it's not going to totally go away, but you're going to be talking about a company having to allege that they suffered some competitive harm to get into court. So this is going to apply to all cases without exception, pending on or after September 16th of this year. So already I think many of these cases have been dismissed. And it's expected to really reduce the number of these false marking cases that have been filed by law firms or non-practicing entities. Willful infringement, just so you know, there was a change there, essentially codifying some case law on willful infringement. Failure to obtain advice of counsel cannot be used to prove willful infringement. So that was in the case law, but now it's been codified. it's going to affect patents issued on or after September 16, 2012. So that's, again, we get that next year that will go into effect for that particular issue.
So that is the issue date of the patent, or the principle becomes effective for all patents that have been issued?
I think it's the issue date of the patent. That's how I read it. Patents issued on or after September 16, 2012. Joinder of parties. Now, this is another provision that may have some impact on non-practicing entity litigation. Particularly in the electrical area, there have been cases filed against dozens and dozens of defendants in one lawsuit. And I think that was deemed to be kind of an abuse of the judicial system, and it certainly made it difficult for judges to deal with those cases. So new Section 299 has a much more restrictive definition for when you can join parties together in a lawsuit. And you have to meet all these requirements. So the right to relief has to be asserted against the parties jointly, severally, or in the alternative. Has to arise out of the same transaction, occurrence, or series of transactions. Has to relate to the same, to the making, using, importing, offering for sale, or selling of the same accused product or process. So again, that's a restriction. And questions of fact common to all the accused infringers will arise. So if you can make all these showings, then you can join parties together or consolidate them for trial. So it's more restrictive. Yes?
Are those cumulative? Or?
It's all these things together. So you have to show all of those together, which is it's more restrictive than the current rule. At least that's the interpretation most people have. It's more restrictive. So the law specifically says that if you allege infringement of the same patent by many different entities, that's not enough. So you can't just allege that 87 companies are infringing your 135 patent. That's not going to get you into court in one case. Yes?
So if you have like a series of a process, and you have claims for Part A of the process, claims for Part B, and claims for Part C, and they all work together, and you've got defendant A, B, and C, which are infringing separate claims of one or more patents, you would not or would be allowed to charge.
It sounds like maybe you would. They sounded pretty closely related, but is it the same process? You're saying a different claims process, 3 separate claims?
Yeah. No, it would be like a computerized process with numerous participants.
Right. I mean, you may be able to show in that circumstance. You may be able to meet these requirements there. It sounds like possibly. You still have that divided infringement issue maybe that's coming up at the Federal Circuit. That's going to be a hot issue. But it's more restrictive, and essentially the other thing is that the infringer is allowed to waive that. If the infringer believes there's no problem with having everyone together in one case, they can waive that limitation. Okay, so this affects all civil cases commenced on or after September 16, 2011, so it's in effect now for new actions that are brought in district court. And it is expected to reduce the number of defendants in the large suits filed by non-practicing entities. And you may have a situation where more suits are filed, probably in the same jurisdiction, for example. So you might, in the Eastern District of Texas, a popular place for these cases, you might have, instead of one case with 30 defendants, they might file 30 separate cases in the same district. So depending on the cost, that could get expensive with filing fees and local counsel fees and everything, but they may, if it's a big enough case, they'll probably do it. One question I have is, if you have that situation where the patent holder files 30 cases in one district, 30 separate cases, is the district judge going to consolidate them for discovery? Is the district judge going to keep them together for claim construction, for summary judgment, everything but trial? It's probably that could happen, because from the judge's point of view, the judge is concerned about efficiency and economy, and splitting these all up into separate cases when they all maybe they relate to the same patent, a lot of the same witnesses, and so are you going to have 30 separate depositions of the inventor rather than one deposition? So I think you're going to see case management come into play here, where the district judges manage these cases in a way that's efficient, and then if they have to try them separately, they will. But they'll kind of fight it tooth and nail, would be my guess.
30 separate Markman hearings.
Right, 30 separate Markman hearings. I can't see the judges doing that. So, right. Anyway, that's all. That was a quick run through some of the highlights, impacts on litigation, but I'm happy to answer any questions you have on that topic at this time. Thank you.